All right, ladies and gentlemen, this is the state of Georgia. One second. This is the state of Georgia versus Mr. Garland Wilson. This is 18 SC 161512. Today is March the 15th, 2022. And we are on Zoom. We are exclusively on Zoom this morning. And so I want to just say a few things from an introductory perspective. Number one, this is a continuation of a hearing that began on January 25th, 2022. I am in chambers. There is a criminal jury trial going on in 8A. We literally have no other space available. And so I have made the continuation of these proceedings available and accessible to the public who might otherwise come into the courtroom on the court's YouTube live stream channel. And if you will look on the top left of your computer screens, you will see live on YouTube. The purpose of the court's YouTube live stream channel is, again, and you've heard me say it, and I say it totally from the heart, to meet our solemn obligation to keep the public's business open and accessible to it. Before these proceedings conclude, and everyone is invited to remind me, I will stop the YouTube live stream, and it is my understanding that that takes the case off of the YouTube without it being on YouTube as a hearing accessible afterwards. In the event it remains on there, I will have to go to the IT department to have it removed. However, it is also being reported this morning, and we appreciate Ms. Blackman being available for us to do that. And then I'm going to stop talking in a minute and turn it over to y'all. But first, I do want to say that I have sounded for Mr. Zaki Hill, both in the hall, all down the hall, and in the courtroom. And Zaki Hill does not respond. So I'm going to turn this over in just a moment to Ms. Foster to put anything else on the record that she wants to put on that. And then finally, for my preliminary remarks, I do have, and just wanted to note for the record, that I do have the State's Exhibit 1, which I believe is the jump drive with the film on it. And I believe the film is that I have actually two jump drives in here. Two jump drives from the state. State's Exhibit number 1. I believe these contain the film we saw either in whole or in part with the lady bus driver. And those were admitted into evidence without objection. So with all those introductory remarks on the court's part, I also want to note that Ms. Weitzel is joined us, and welcome.
Thank you.
Okay, Ms. Roberts and Ms. Foster, who would like to go first with any of that?
I just want to let the court know that Detective Garman is on Zoom.
Hey, Detective, how are you? Okay, Ms. Foster, do you want in any way to address the Zaki Hill matter? You're on mute.
I'm sorry, Your Honor. Yes, we did. As the court recalls, last time we were in court, the state had initially subpoenaed Mr. Hill. He did not show up at that time. We then, after the case was reset, subpoenaed Mr. Hill as well. We did file the subpoena with the court on February 17th. He was served via certified mail. There is a return receipt that we did receive that I can provide to the court, which is allowable via statute. And Mr. Hill did not show up. When we learned from the court that this hearing would be via Zoom as opposed to in person, because the first subpoena did let Mr. Hill know that he was to appear in person. We did then send Mr. Hill a statutory overnight mail, which was delivered, and I believe we filed that with the court as well, letting him know the Zoom link and that he was to log on via Zoom. So Mr. Hill is a necessary witness. He was properly subpoenaed. He was served with the subpoena, and we do require him to be present in court and to further our argument today.
All right, Ms. Foster, my understanding, let me just make sure I got this straight. The state subpoenaed him for the hearing on January 25th. Is that correct?
Yes, but
And he did not show up. Is that correct?
Because, Your Honor, the state.
Wait a minute. Ms. Foster, you said that the state subpoenaed him on for the January 25th hearing, correct?
that is correct, Your Honor.
And that he did not show up, correct?
Correct. And there was no release of the subpoena to my knowledge.
Okay. All right. What, Ms. Roberts?
The reason he did not show up for the 25th hearing was because we released him from his subpoena.
Okay.
Your Honor, I will state.
No, wait, whoa. Okay, so the state released him. I mean, did you release him after he showed up?
We released him prior to the hearing.
By talking to him?
Yes.
Okay, Ms. Foster, what?
I will state in my place as an officer of the court, I did contact Mr. Hill directly. Mr. Hill advised me that he had not spoken with anyone from the state. And he said he was not going to be in court and he wanted nothing to do with this case and hung up on me. So I will state that in my place. And I did address that with Ms. Roberts last time we were in court, that he indicated that he had not spoken with the state.
Okay, so Ms. Foster, my understanding of your remedies at this point, assuming valid service of a subpoena, is that, and assuming that the witness has not shown up, is that we would continue this matter.
I want to proceed with this case, and then at the end, can I readdress it with the court, whether or not I wanted to continue it?
So here's what I heard. Now, here's what I presume. You want to just get everything we can get done, and then see if we need Mr. Hill? Is that essentially what you're asking?
Essentially, yes, Your Honor.
I have no, Ms. Roberts.
Are you saying just basically finish our direct examination and cross-examination of Detective Garman, and then at that point you'll decide whether or not you want to call Zyke Hill?
No, that's not what I'm saying. After you finish with your witnesses, I'm going to speak with my client because he does have the right to testify if he chooses to do so. I've spoken with him about that. So I will just need to check with my client and then I can address the court at that time.
Well, I think Ms. Roberts asks a valid point, though, because I think the issue before me right now is the non-appearance of Mr. Hill. If the request is simply for judicial economy, that we go ahead and take who we got, and then we address whether you would like a continuance. Okay, I'm not saying okay, but I understand. But if I'm not sure I connect why it's necessary to then determine whether the defendant wants to testify.
Because, Your Honor, for immunity, of course, we are arguing self-defense. My client does not have to testify. He has a right to remain silent. But I would have a right to continue with my case and call witnesses. My client may be one of my witnesses. So I guess what I'm saying is the court is correct. I don't want to keep pushing this case out. And I would like for judicial economy for us to take what we can, and then we can address whether Mr. Hill, whether we're asking that for this case to be continued for us to produce Mr. Hill.
Okay, Ms. Roberts, do you have anything else to say?
Yeah, Your Honor, the defense has the burden at this hearing of proof. The state doesn't have any burden at all, which we did out of judicial economy, take our witnesses out of order and take one of our witnesses prior to the defense concluding their case, but they have the burden of presenting these witnesses. So I would object to them wanting us to present our entire case and then her make her decision as to what witnesses she would call. She needs to, we need to
You always get to do that, don't you?
Yeah, I don't know what she's talking about. I never went to.
Let me do this. That's what they always get to do, isn't it?
Not in an
You know what
immunity
your case
motion.
is?
They go first, Your Honor.
Oh, okay, that's fair. All right.
And that's fine. We'll call Mr. Detective Garman. He was already on the stand, so I assume that the court didn't want to take the witnesses out of turn. So because we already spoke with the bus driver. Detective Garman was actually testifying first. When we got into the issues with Mr. Hill, that's when the court called the bus driver. So
And the bus driver was Ms. Leonard.
Yes.
Ms. Shakita Leonard.
All right, here's what we're going to do, guys. We're going to go ahead. And so, Ms. Foster, Detective Garman is your witness?
Yes, Your Honor, he'll be my witness. But
Okay, we're still, and I apologize, we're still on the defendant's immunity case in chief.
Correct. Yes, Your Honor. But the state was allowed to question Detective Garman first, but I'll proceed.
No, I wasn't.
Okay, hang on. Here's what we're going to do. We are going to finish with Detective Garman. At that point, I will ask the defense to tell me whether they want it continued for Mr. Hill or not. I don't really see how the determination of whether the defendant testifies comes into the Hill question. And I don't need to know your strategy. And I'm not asking you to reveal your strategy, but let's do what we can do, and then we'll move on from there. Okay, but let me just make sure I know where we are. So we had Detective Garman up. He started at 11:32 on January 25th. We took a break. We then argued about Mr. Hill. Then we stopped. I think Ms. Foster may be right. We stopped with Detective Garman, and I believe out of courtesy took Ms. Leonard. And we ended with that. Okay, so let's resume, I believe, the direct of Detective Garman. And may I stop us just a second and go off the record? Hey, Ms. Lake, you need to tell me anything else about anything?
Your Honor, I do have two additional announcements.
Okay.
So Judge, on the P&A calendar, position number 11.
Wait.
Mr. Brown.
P&A position 11. Okay.
So Mr. Brown does not qualify for a public defender. We are asking that it be reset to the next available P&A calendar so he can hire Scott Smith.
Okay. Set to next P&A to hire Scott Smith. Ms. Roberts, Mr. Brown was here. I encountered him pleasantly, and I think that request is reasonable. Do you have any objection?
Sorry, I'm on mute, but no, I don't have any objection. I remember that he was present.
Okay. All right. What else, Ms. Lake? And then we'll let you go.
Thank you, Judge. Position 12, Ms. Gregory.
Yes.
We will waive formal arraignment and enter a not guilty plea in her case.
Okay. And she was present on Zoom, right?
Yes, Your Honor.
Okay, waive arraignment, plead not guilty. Is this you? Who's this?
Kara Roberts for the
Okay.
state.
Ms. Roberts, you are the utility infielder today. Okay, so status?
Yes, please.
Okay, Ms. Roberts, that's what we're going to do. Thank you once again, Garland Wilson case, for letting us pause. All right, Ms. Blackman, we're back on the record. And proceed, Ms. Foster.
Yes, Your Honor. I believe Detective Garman he was sworn last time because we were questioning him.
All right, Detective Garman, this is Judge Barwick. I just want to remind you, sir, that you were sworn in before. You remain under oath. Go ahead, Ms. Foster.
Yes, Your Honor. Detective Garman, I believe the last time we were talking about your interview with Mr. Hill at Grady. Do you recall that?
Yes, I do.
Okay, and can you just back up a little bit? Tell the court how you got to questioning Mr. Hill at Grady.
Yes, Mr. Hill was at the hospital with one of our officers, and I was notified by that officer that Mr. Hill wanted to speak with investigators.
And did you get a chance to speak with Mr. Hill?
I did.
And that was recorded via audio, correct?
Correct.
Okay. And your investigation in speaking with Mr. Hill, tell the court what you discovered.
Mr. Hill stated that
Your Honor, I'm going to object to hearsay.
All right, Ms. Foster.
I'll rephrase the question.
Okay.
Without telling the court what Mr. Hill stated, did you learn that there was an altercation between Mr. Hill and Mr. Wilson prior to the bus incident?
yes.
And in that prior altercation, you learned that Mr. Hill had taken something from Mr. Wilson, correct?
I'm going to object to leading the witness.
Okay, I think he is your witness, Ms. Foster. What is your response to that?
I will rephrase.
Okay, thank you.
Tell the court what you learned about the prior incident.
From speaking with Mr. Hill, I learned that him and Mr. Wilson had a prior altercation at a bus stop. He wasn't able to identify which particular bus stop. He just stated that Mr. Wilson.
And Your Honor, I'm just going to renew my objection as to hearsay, as to what Mr. Hill told this officer.
Okay, well, let's go ahead and get one thing out, which is we've got a hearing on an immunity motion, and just tell me, y'all just tell me, is this subject to the same type of rules that one would encounter at bond hearings or other pretrial motion hearings where hearsay is specifically allowed? Or does this carry the burden that trial or evidentiary hearing might carry with regard to strict adherence to hearsay rules? That's my question. Because here's an investigating officer that did an investigation, and ordinarily the court would not only hear hearsay, the court would welcome it. So tell me what rules of evidence we're proceeding under.
Your Honor, it's my understanding that hearsay is not admissible at this proceeding, as it would be at a preliminary hearing or a bond hearing.
All right, Ms. Foster, you want to tell me what you think?
Yes, Your Honor, we addressed this last time. This is an officer, and I believe that there is a hearsay exception that we discussed last time. This is an officer talking about it's not being necessarily admitted for the truth of the matter asserted, but for what he did in furtherance of his investigation. So the hearsay objection last time was 803. Let me get the exact. But I believe, Your Honor, that there is a hearsay exception to this officer testifying as to what he did in the course of his investigation and what he learned. I'm not asking him to tell me exactly what Mr. Hill did, or I'm sorry, said, but based on what he learned, what he did next.
All right. Just hang on one second and let me just look at my notes real quickly. All right. I don't have specific notes regarding prior objections and my rulings on prior objections. So let's look at this under 803 now.
Yeah, that was the objection. It was 803. 6 and 7 was what I raised last time, that this was records that are kept by the police department in furtherance of their investigation. And then also 803 7.
And read it one more time or tell me what that particular exception is.
One moment, Your Honor. Let me just.
And I apologize. I'm in my code is in the courtroom.
Give me one moment, Your Honor.
Sure.
Your Honor, off the record, please.
Oh, yes.
May I be excused?
Are you involved in the Garland Wilson case?
No, Your Honor.
Okay, good to see you. Thank you for coming.
Have a great day.
You too. Okay.
Yeah, it's 803, is 24, OCGA 24-8-803 6.
6. Okay. And what does 6 say?
It's records of regularly conducted activity. And my argument, Your Honor, is that this officer, they have to make records of their investigation, which this officer did. And my argument is that this hearsay exception applies because it was made at or near the time of the described events, acts, or conditions, opinions, or diagnosis made by, well, let's see. I'm sorry, actually, it's kept in the regular course of conduct.
Yeah, I don't think we have that, but give me 1 second.
And Your Honor, I have a couple cases that I think would be, and I could provide quotes from them.
Actually.
All right, go ahead.
Yeah, and I was actually able to, actually, I think 803-8 is more applicable to this officer.
Okay, what is 8? Just Ms. Roberts, hang on. What is 803 8 say?
Public records and reports, says except as otherwise provided by law, public records, reports, statements, or data compilations in any form of public offices setting forth the activities of the public office, or this is the part that we're saying applies, matters observed pursuant to duty imposed by law as to which matters there was a duty to report. Actually, no, this doesn't apply. Never mind, Your Honor. I think this is what we discussed last time.
And Your Honor, in Brown versus State 274, Georgia Supreme Court case from 2001, it says
The page number of Brown.
the page number
You said 274 Georgia, what?
31.
31, okay.
It says, we conclude that narratives contained in police reports generated in connection with police investigations are not the appropriate subject of an exception to the hearsay rule. They conclude that evidence contained in the police report narrative were not facts that should properly be admitted under the business record exception to the hearsay rule.
No, I don't think they're business records. I mean, I definitely don't think they're business records. The very nature of business records is the routine nature of their entry.
I would also say that Mr. Hill is under subpoena, and if we do continue this case, the state will have an opportunity to cross-examine Mr. Hill, which would resolve their objection to hearsay. If Mr. Hill was in fact here, as he is under subpoena to be, then these statements by the officer would be admissible.
Problem, Ms. Foster, that I'm having is that I don't think that there is anything more tied to the truth of the matter asserted than these statements. What did the victim say? I think the following, that there is another provision, and if you'll give me just 1 second to find it, it deals with the absence of the unavailability of the witness. And that is going to be found at all right. Give me just
804, Your Honor.
maybe that's it. Hang on. All right. Unavailability of a witness. All right, so under 24-8-804 parentheses 5, close parentheses, the term unavailable as a witness includes situations in which the declarant is absent from the hearing and the proponent of the statement has been unable to procure the declarant's attendance, or in the case of exceptions under 2, 3, or 4, the declarant's attendance or testimony by process or other reasonable means. So I'm wondering aloud whether that applies here, and it sort of gets to the issue of Mr. Zaki being unavailable, and it gets, or he's not replying or honoring the subpoena. The remedy for failure to abide by a subpoena is a continuance, but as to 804 parentheses 5, subsection 5, we get kind of squarely to the issue in that he didn't show up when properly served. So that makes some assumptions. We haven't found on the record that he was properly served. We specifically held under advisement whether he had been, whether we would seek a continuance to add him as a witness. So I think, unfortunately, Ms. Foster, we kind of have to face this issue squarely in the face right now, because I'm not going to let this witness testify to something that an out-of-court declarant said because the out-of-court declarant is unavailable, but then also let us continue it to make that person available.
If the court were to grant a continuance, how soon will we be able to be placed back on the calendar?
Maybe not the most appropriate question legally, but I'm happy to answer it practically. Hi, Ms. Weitzel.
Yeah, let's see here. I'm looking, hold on one second. Let's see.
Assume for the sake of argument that it's in person. I think we've flirted 2 times now with part Zoom and now whole Zoom.
I have to sign back in on my internet because the thing disconnects. Hold on. Okay, now let me see here.
While Kathy's doing that, Ms. Foster and Ms. Roberts, I think 24-8-804 subsection A, subsection 5 would arguably apply. The defendant tried to get him. He did not attend. And now they want to introduce what is clearly hearsay. But all I'm saying is you don't get 2 bites at the apple. You don't get to just put his testimony in via another witness and then say, by the way, I want a continuance.
Yes,
And
Your
I
Honor.
think that kind of sounds fair. If anybody disagrees with that, let me know.
Well, and Your Honor, may I address the 804 exception?
Sure.
So my understanding is that subsection A5 defines what an unavailable declarant is, and then code section B is what modifies that and says if someone falls into that category of being unavailable, then their prior testimony that falls under subsection B would not be excluded under the hearsay rule. And I don't know that it says at a testimony given at a hearing, a deposition, in a prosecution of a homicide, a statement against interest. So there are certain elements that are outlined beneath that I think we would then have to, the statement would have to fall into.
Well, I know I've looked at the issue before of whether someone's statement is testimonial. And if this man was in the hospital, either under police custody or being questioned by the police for purposes of the preservation of the testimony or the use of the testimony, I think that'd be testimonial.
Yes, I agree that it's testimonial, but it's saying testimony given as a witness at another hearing.
Well, if you look at 3, B3 and B5 applies directly to him. 1, it's a statement against his interest. 2, it was offered against a party that you're saying has engaged in wrongdoing, which would be Mr. Wilson. So I think really B3 applies directly to Mr. Hill.
Before we get to that, Ms. Weitzel, what does it look like?
May 3rd.
May 3rd.
Your Honor, my client wants to resolve this case, but I think that the court needs to hear for an immunity motion. And even, I'm not sure why the state is trying to limit the court from hearing what really happened, but I understand. Your Honor, I will have to ask for a continuance. We will subpoena Mr. Hill again for the third time. If the court recalls, he was subpoenaed the first time. The state is saying he was released. There was no proof of that. He was subpoenaed for today. We will subpoena him again for May 3rd, but I will let the court know he has told me he's not going to show up to court.
And I think the question then becomes not for this court, but I think the question becomes at some point whether how we proceed, how the state makes its case without him, but that's not my business. Ms. Roberts, any response to the request for continuance? Not request. I mean, I don't want to put Ms. Foster in the position of arguing, to put this off. I think, go ahead. Any response?
No response other than that, as an officer of the court, because Ms. Foster had indicated that there's no proof and that I basically was misleading the court about whether or not he was released from his subpoena. I can call my investigator if the court needs proof.
Here's what I think. I think that number one, and suggesting this for the record without saying let's put this on the record, but suggesting that our courthouse COVID requirements are being reduced. In other words, access and accessibility to our courthouse is being opened up more. And while we still have a mask requirement, and we'll continue to have a mask requirement for the foreseeable future, we are increasing juries. We are lessening social distancing. The point of this being, we're back to business in the courthouse. We have been eternally indebted to the technology represented by Zoom and others to be able to get business done. But I do believe, absent some specific request, we all need to be in the courtroom. And so I'm going to ask everybody that on our reset date and for our reset notice, unless there's some specific reason, we need to be in the courthouse and we need to be in the courtroom. And I am going to continue the case due to the non-appearance that I can find. And once again, I sounded in the hall, I sounded in the courtroom, we sounded on Zoom, and Mr. Hill is not present. Anybody got anything to say before we adjourn today?
Ms. Foster.
You go first. Go first, Ms. Roberts. What you got?
I just wanted to let Ms. Weitzel know that Detective Garman, who's also on the call, will be out of the country May 3rd. Detective Garman, if you could speak up, you could possibly let us know when you will be back or what your options are, if you can hear me.
Yes, I return back to the country May 9th. So anytime after that is perfect for me.
Kathy?
Oh, Lordy, let me see. I don't have dates after that, but I will. So anytime after May 9th, I will put it on the first day.
Or before.
Yeah, I was going to say, I don't know everybody else's availability, but before works for me as well. So I'll be gone from April 28th until May 9th.
For you.
I don't have anything before then. So it will be after that, the first date after that.
And I don't want to keep pushing this back, but I just want to let Judge Weitzel know that I do have a leave filed in June. So as long as it's not in the middle of June, I'm fine with that.
Okay. I've noted that, so we will not.
You go into the Family Law Institute, Ms. Foster?
I am. Are you
Okay.
going?
Well, I guess we don't want the whole world to know that
Coming back.
our travel schedules, but okay. Well, I will have you covered on that. So as soon after May 9th as we can do it, we're going to have to massage the calendar and we will get back to y'all. And Mr. Wilson, thank you for being present via Zoom, and you remain subject to the terms and conditions of your bond.
Thank you.
Okay?
And I will, okay, I guess once I get the date, because I do plan on sending another subpoena to Mr. Hill. So I'll just wait to receive that from Ms. White, so I'm sorry.
Okay, we'll get it out to you quickly. I really want to thank Ms. Blackman. She stepped in and was rather heroic in getting to us. We can go off the record now if that's okay with everybody. Guys, we're busting at the seams. I mean, the good news is that we're getting juries back and we are able to, start trying some very old cases and that need trying. We just don't have anywhere to go. So continue to be a little patient with us while we work our way through with some funds, but just trying to find some space. If anybody wants to have us over to their house, let us know. We'll bring our own security. We can start doing some hearings outside. Y'all, thank you, and everybody stay safe.
Thank you, Judge. You too.
Hey, good to see everybody. And